Yo, what's up, man? Hope everybody having a blessed one. We back with another one today, man. Today we got Young Dolph murder trial, Tennessee versus Justin Johnson, day 4. Today is the verdict day, so hey, they should be closing out with it today. I think this brother is guilty, but hey, we gonna let them decide. Let's get into it.
Sufficient to lead a
Right now, I've been watching a little bit of it. Right now, she just reading the charges out that he could be convicted of.
reasonable person to act in an irrational manner. Facilitation to wit, first-degree murder. Any person who commits the offense of facilitation to wit, first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of that the defendant knew that another person intended to commit the specific offense of first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder has been defined on page 8. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, second-degree murder. Any person who commits the offense of facilitation to wit, second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of second-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder has been defined on page 9. Knowingly means that the person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally or knowingly, and that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct where that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, voluntary manslaughter. Any person who commits the offense of facilitation to wit, voluntary manslaughter, is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following elements: that the defendant knew that another person intended to commit the specific offense of voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the voluntary manslaughter, and that the defendant furnished each such assistance knowingly. Voluntary manslaughter has been defined on page 13. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who facilitation to wit, aggravated assault. Any person who commits the offense of facilitation to wit, aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the aggravated assault, and that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Simple assault. Any person who commits a simple assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or recklessly, or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser, that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict
This week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions, and it's even harder to hide who you are. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? So the defendant, Justin Johnson, is charged with 3 counts. Conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us, and he told us that he met Justin Johnson through Hernandez Govan, and that he knew Justin was a rapper, and he was also known by the name of Straight Drop. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify defendant in open court, and during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting and facilitating. And, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is 1, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. Second, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. Third, you have to prove that the killing was premeditated. And as we saw, or as we learned in voir dire last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car. You held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children. She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who was now deceased. Later on, we heard from Dr. Scantleberry. She was the medical examiner and performed the autopsy. She found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hopkins. He testified that he was head of Dolph Security for years. He was able to identify Dolph's car in the beginning of the Makitas video, and he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? Back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing. He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the Makitas parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at Makitas. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Jook. In that FaceTime call between Big Jook and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Garden, you didn't mistakenly follow someone's car into Makita's parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early. Not only did he place an outgoing call to Big Jook, He also received a text from a Kiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. You have all the evidence, all of the testimony, all of the stipulations, all the videos, all the photographs, and now it's time for you to consider that evidence and apply your common sense. And after you do that, I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams. Mr. Evans.
Thank you, Judge. See y'all again. This is the last time you're going to have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court and Mr. Hagerman, Cyrus, all of us agree that you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible, and the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. And on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper, wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley, engaged in a music video, right, for his rap. Hat kicked to the side, kind of grin on his face, because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make beyond a reasonable doubt is the heaviest one, maybe one of the heaviest decisions you'll have. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have. And I'm sure you have. And not to talk about.
I could say even if they kept an open mind, you ain't making no easier for them to size it. Like it been a one-sided thing since it jumped off. This shit been an open and closed case so crazy they didn't even call all the witnesses. We supposed to seen Govan and some more shit. The other shooter testified and a nigga blood brother testified. And the nigga that was pumping the gas testified. That's all they needed.
About the case, the thing that you've been listening to for days, with people all around you that have going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully, to listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like Cornelius Smith and that conscience, right? Because I don't think he really meant that when you heard from him. He said, the reason I decided to tell the truth is I got a conscience. And we all know that's not the type of thing you're dealing with. you take that more seriously. You mean it. He didn't. You've heard a lot of concepts, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains. He didn't kill Adolph Horton Jr. He didn't conspire to kill Adolph Horton Jr. And he wasn't the man holding the pistol in the Makita video. And it's going to be up to you to decide.
How that wasn't him though? What you mean that wasn't him in the Makita video? How though? Like you never he never told us how that wasn't him. Like he told us that wasn't him, but the nigga never told us how. Like he just telling us that's not him. Like it's like he trying to tell us that he had the same outfit that someone else had on that day. 3 times. Same dirty ass drawers and all.
That. To watch those videos. Watch them close. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar. It doesn't mean the same.
Bro, you had the same outfit on, though. But what are you talking about?
Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And
oh shit, the judge rolled her eyes like she even know it's bullshit.
We learned through the proof, in Memphis especially, and elsewhere, Bass Pro ads. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it. Other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson and said, that person always wore a Bass Pro hat. And you have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand, says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments, you look back at the Makita video, those are the same underwear. Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same?
Bro, them the same dirty ass drawers, bro. He trying to help this nigga go to jail. Nigga, them was the same dirty, filthy ass drawers he had on.
And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore. And I agree. Right? We've got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics. Right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelius Smith said he wiped it. And we'll get to whether you believe that or not in a minute. Okay? But I want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos.
Bro, the daughter ain't in the car, bro. They dropped the daughter off. Just like we seen a video of them switching the car and we really couldn't see who switched the car. Come on, bro. Of course they took the daughter out the car. Like, what the fuck? They had a lot of time to switch the daughter out the car. We already confirmed that, nigga.
You think, he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. During proof, it was interesting because they would show the Mercedes go in across town, and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building, or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel. When they're doing crosstown, Jerry would have been. And when you're looking at his slides, you know, you've got that really thick PowerPoint exhibit, you'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small. They're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, like, at all. That Justin Johnson was present for any meetings. That Justin Johnson got a penny for killing Adolph Thornton and didn't have to give it back.
He did.
And say, believe it. And one of the things that you have to kind of ask yourself is when you see Mr. Johnson in the elevator with his little girl leaving crosstown that morning. And of course, you know there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then of course Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time, and put an officer on the stand, the lieutenant, to talk about getting access to the time, you know, how he got the timestamp. But what that shows you is this: they don't know what time it was. Had to have a technician. It's a computer. I don't understand it, but when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say it is not uncommon at all to pull surveillance cameras that have inaccurate date and times. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelia Smith. They got to leave, then turn around and go to Bradley and go back to the white truck. Right?
The only one that's
And
awesome
then
that they did it, bro.
get out and be in front of the Makita Cookie at 12:21. That part of common sense and your everyday experiences, what does that tell you about going one place to the other? Right? Takes longer, right? If you're stopping places, if you got to park, if you're presumably dropping a child off, there's going to be some kind of a exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. And all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved the Mercedes to the backyard, all of that, according to Cornelia Smith, should have been captured on Hernandez Govan's home security system, right? He said Govan.
He taking that theory to the heart. He keep on saying Govan had a camera, so why nobody got the footage? Nigga, what the fuck? They didn't get it. Alright, but like, what they gotta do with anything, bro? He keep on talking about the footage where we don't see straight drop. Nigga, talk about where we seen him, bro. Like he don't wanna talk about that.
Man had the security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember. He texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. You know, he didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez Govan. We don't necessarily know if they did or didn't, because we didn't get to hear from Mr. Govan. You know, I asked Detective Browning if he was aware of any video from there. No. If Cornelius Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22 when he was meeting with law enforcement. And you know, I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went, but we don't know.
With a little Memphis talk. Those cookies are fire. I think that's how we started it. Little more Memphis talk. What y'all even talking about? What y'all even talking about?
What y'all even talking about?
A missing witness? Hernandez Govan? A missing.
We don't need Hernandez. They don't need Hernandez. So I guess he tried to use that on them, like they don't want to bring in some of the witness because it's gonna mess up their case. That's what they're trying to say.
Witness? Hernandez Govan? Absent material witness. And the defense wants to say that is Hernandez Govan? What do we know about Hernandez Govan? He's a defendant in the case. He is charged with murder and conspiracy to murder. Whether it's from television or whether it's in black and white at the bottom of that same instruction, a defendant has the right not to testify and incriminate himself.
He did not. He ain't testify.
He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here and testify. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, is actually what they used to call it, where you didn't have that right not to come in court. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe him? Or look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's caught. So don't believe him. So I made a mistake on one slide about the time, so it was corrected. So we can't believe the video. You know, there's a word that actually exist, because it's a thing, is corroboration. Is corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kissing Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car, and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Valero video, which shows something strange. Shows something strange. Shows Kissing come up in the car and then somebody else get in and drive off. Strange. Another little piece of corroboration, where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. But my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Haven Court video. We don't just have a Crosstown video. We don't just have a defendant who's like, Cornelius Smith, I'm guilty and so is he. That's us two in the parking lot shooting him. We've got Justin Johnson's actual phone. We've got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, and as soon as you see the video of Crosstown of him leaving in the exact same outfit, in the white Mercedes, case is over. But we keep going. As soon as you hear from a co-defendant who's like, that's me in the parking lot shooting Dolph, I'm going to prison, and Justin Johnson's the guy next to me doing it, case is over. As soon as you see the Haven Court video, 40 minutes after the shooting of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, it would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we have a text. The night before the homicide, we have a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of the white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Kissed and said. They met on Bradley. Then they drove to Valero. And they switched cars. That's corroboration. So do you have to be willing to trust Kissing Gardner with the keys to your car? Of course not. You think I trust Kissing Gardner with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because it's on video of Valero. It's documented in his phone with literal pictures and locations. This is plain and simple. Do I have to believe that Cornelius Smith is talking because of pangs of conscience? No. No. He's talking because he got caught. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like Kissing Gardner's, that we can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I miss a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamar and Sons. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, real tricky truth test. Justin's driving the white Mercedes. You see it in the video, of course. Cornelius testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway or there on the front. Well, we know the white Expedition is also Justin's car. We've seen it across town for testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called the 2 Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? The white Expedition. Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat, just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting. Justin's driving the white Mercedes. He hands me the keys to the Expedition. We get to Bradley. I jump out. I get in the driver's seat of the Expedition. Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in the Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax come, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the 2 pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we do in trials. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments when this trial was just over again for the 5th time was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and then FaceTimes with somebody. He says it's Big Joke. The guy that put the money down for this. Number 2 is CMG. Guy that put hits on the other artists too. Cornelius says it's a FaceTime. Spelling out Dolph with your hands. And what do we find in Justin's phone? I mean, delete the stuff all day long. He did. Whole day. November 17th. Delete it all day long, but it's still in there. A call and FaceTime interaction with him. Justin Johnson with Big Joke. Who Big Joke? Cornelius tells you. And there you see it in black and white. Similar Mercedes? No. Back end damage, just like we saw in the video. during the murder. Again, caught on video. White Mercedes, back end damage. The exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you calling? Who you texting? Big Joe. Caught before.
Yeah, you doing?
Caught during. And then caught after. At Haven Court. Video of them arriving. Cornelius driving next to him, and they drive and go do it. No, we don't need Memphis talk for that. It's called
Just walking in the motherfucker.
Just Do What's Right. It's as simple as that. Just do what's right. Cornelius Smith and Justin Johnson killed Adolph Lord Jr. November 17th. We watched it happen. Cornelius Smith, Justin Johnson, Hernandez, Govan, Big Jook, they all conspired to have it done, and it was done. November 17th, 2021. And as he did it, he was already a convicted felon. He should be found guilty of all counts. You do what's right.
We're going to pick up on page 29. Outside of the jacket, and sign one of your names to the verdict as foreperson. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are. All 12 of you will deliberate at the same time. There should never be an opportunity where 2 or 3 over here eating and the rest of you are deliberating. If you decide you're going to eat, everybody eat. If you decide you're going to take a break, everybody take a break. When it's time to deliberate, everybody deliberate. Just let the deputy know that you're doing something different besides deliberating. Okay? Ladies and gentlemen of the jury, have you reached a verdict?
You have your own.
Four-person? If you would stand and read your verdict, please.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder.
Oh!
Four-person? If you would stand and read your verdict, please.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment.
How could Straight Drop keep a straight ego? Look at him. What the fuck?
We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment.
You seen her? She said, damn, he guilty of first-degree murder. Damn. He cooked, bruh. 2 charges so far.
And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Damn, look at her. She about to cry. What they thought was gonna happen, though?
Thank you. Juror number 1, is that your verdict? Juror number 34, is that your verdict?
Yes.
Juror number 35, is that your verdict?
Yes.
Juror number 11, is that your verdict?
Yes.
Juror number 14, is that your verdict?
Yes, ma'am.
Juror number 17, is that your verdict?
Yes, ma'am.
Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict?
Yes.
Juror number 25, is that your verdict?
Yes.
Juror number 44, is that your verdict?
Yes.
Juror number 23, is that your verdict?
Yes, ma'am.
Juror number 28, is that your verdict?
Yes, ma'am.
Thank you. Ladies and gentlemen, I want to thank you again for your time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you've made. Thanks again for your time and attention.
She looked down at Justin hands like they so worried for him. They all like, damn, how is he keeping his composure like this? This a young brother. He was ready for this. Like his composure is just straight up. Like he not crying. He don't look worried. Like to keep it real, we want him to look worried, but to be honest, he don't look worried to me. He's fucked.
You are excused.
Jurors excused.
Mr. Johnson, the jury having found you guilty of conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. As the 13th juror, I affirm this verdict. As to the first-degree murder, I sentence you to life in prison. I will set punishment as to the conspiracy and the convicted felon in possession of a firearm after a sentencing hearing. The date for that hearing will be November 1st.
Yes, Your Honor.
November 1st. There's nothing else to take up?
We will prepare the judgment sheet and pass that forward, Judge.
Thank you. And the pre-sentence report. The order for the pre-sentence report.
Sir, once we get that, we'll get those to you.
Thank you. Give me a adjourn court.
All rise. This honorable court stands adjourned to Monday morning at 9 a.m.
Mr. Hagerman, have you heard from Mr.
I've
Roy?
been texting with him, and he hasn't given me a date yet. My sense is next week is not good.
Okay, they gonna get whatchamacallit in there next. His shit gonna be quick. He gotta plead guilty, so he ain't gonna go through all this. The other guy, Quindarius.
And then he said he had a jury trial the last week of.
Yeah, that's it, man. Justice for Dolph, man, was set today, man. JJ got life in prison thanks to his lawyers. They helped him the time he deserved. Let me know what y'all think in the comment section. Do y'all think he got the time he deserved? Do y'all think they got it wrong? Do you think that was him and them dirty ass draws? Or you think that won't him? Hey, hit me up and let me know something. Why don't y'all go ahead and like, comment, and subscribe. Please do that for your brother. Please. I'm begging you, please. But nah, for real though, y'all have a blessed one, man. See y'all on the next video.